I say to you?
You didn't say it, you wrote it and you signed it.
I wrote that said you had no contact with a lawyer.
Yes, sir.
Okay, I don't have that. Do you have that with you?
It's in your file.
I don't know what document you're referring to. That's why I'm
It's called a bond order. It's dated September 16th, 2011.
Okay. The bond order doesn't say that.
Yes, sir, it does.
Okay. Well, let me tell you, and I will pull that. Under no circumstances did I ever say or mean that you're to have no contact with a lawyer. Do you recall me saying that if you want a lawyer, I'd be happy to appoint one for you?
Not on September 16th, no, sir.
Well, you're sentencing. On your appeal, I gave you your appeal rights. And you told me in that sentencing, because you had terminated your lawyers, and then during that sentencing process, I said, are you waiving your right to have an attorney? And you said, no, I'm not waiving my right to have an attorney. I do want an attorney. And I said, okay, would you like me to appoint an attorney? And you said, I'm not waiving my right to an attorney. And I said, I would be happy to appoint you an attorney, but you have to ask me to have you appoint an attorney. You have to ask for that, and you have to fill out an affidavit. You said, I'm not giving up my right to an attorney. So you never answered the question. You just kept saying the same thing over and over again.
Sir, I said I had an inability to obtain counsel. The fact that you don't know what to do when I say that, I can't help that.
Well, do you remember me saying to you, would you like me to appoint a lawyer for you? And do you remember your answer?
What I like and what I don't like is totally irrelevant to these proceedings, totally. Okay?
Well, no, that's not right.
Yes, it is right. It's my constitutional right
if you
to
want
representation by counsel.
If you want a lawyer, I will tell you again, if you want a lawyer, I would be happy to appoint a lawyer for you for purposes of your appeal, for purposes of your, you want to argue on a bond. I'd be happy to appoint a lawyer. You have to fill out an affidavit of indigency. You have to qualify, but if you are unable to provide a lawyer, I'd be happy to do that, and I've said that many times.
Well, clearly, sir, you do not understand what the process is. Okay. Once I say I have an inability to obtain counsel, you are required to schedule a hearing on my inability to obtain counsel, and then we go from there. And you did not do that.
That's correct, because I never got a request from you that you wanted a lawyer.
I said I had an inability to obtain counsel, and I did not waive my right to counsel. The fact that you did not know what to do, that you don't know what your job is, I can't help that.
Well, I think I know what I'm doing. You may not think I know what I'm doing, but I think I know what I'm doing. And I will tell you again, and this, the purpose of this hearing is to try to clean up any misunderstanding. I will tell you again, under no circumstances did I ever say or ever mean, and I'll say this today, that you are not to talk to a lawyer. You can talk to any lawyer, any 100 lawyers that you want to. It's totally your option.
It's of record. You said that I should have no contact.
I'm telling you today, whatever's in record before, I don't know, I'm going to pull out the bond. I guarantee you it's not in that bond record. But if it is, for some reason, there's some language in there that I don't know about that somebody put in, fine. I'm telling you today, you can talk to any lawyer you want to.
What's funny, my attorneys couldn't even figure it out because they're like, well, let's see. It says here you can't have any contact, direct or indirect, with a lawyer, so it's a problem that you're talking to me right now. So I can't help it that you don't know what you write and what you sign.
Ms. Ogle, what I'm telling you today, and just so that there's no misunderstanding today, is that if you want a lawyer, I will appoint a lawyer for you. You have to fill out an affidavit of indigency. I don't need a hearing to make a determination of whether you're capable or not capable. All you have to do is fill out the form like every person who comes to this county and every county in the 88 counties in the state of Ohio, they have to fill out a form that is prescribed by the Ohio Supreme Court and approved by the Ohio Public Defender's Office. You have to fill out, list your assets, and you have to sign it. It's an affidavit, and then if you fill that out and it's determined that you're not able to provide your own counsel, I will appoint one at no cost for you. So that's the first thing. Now the second thing going on with the bond. You said that as of a particular date, that you will no longer, oh, I'm sorry, you will no longer be able to provide for the electronic monitoring service after November 27th, 2011. There is no free electronic monitoring service in this county that I'm aware of. If there's an contingency program for electronic monitoring, I am not aware of it. I have asked. Are you aware of it?
I'm not, Your Honor, no.
Okay. I will ask again the people who run the program, if there is not a program for people who are indigents, then there's the only alternative is you're going to spend the time in the county jail if you cannot pay for the electronic monitoring. I have great concerns about you being out on bond. I have great concerns for the safety of the public and safety, for that matter, the safety of yourself. And I am not willing, under any circumstances, to grant a recognizance bond. The electronic monitoring is about as far as I was going to go. So, after November 27th, if you do not pay for the electronic monitoring, you're going to be sent to the county jail here.
Okay. I'm not paying for any more electronic monitoring
Okay,
service?
that's fine. As of what date?
I'm not paying for any more. It's paid up through the 27th.
Okay.
And I do not waive my right to counsel in this hearing,
Okay.
that you're holding unlawfully. I have an inability to obtain counsel. I never requested a hearing. And any action that you take regarding the bond or initiating the sentencing is out of your jurisdiction.
Well, you can go to the Court of Appeals and do whatever you want as far as the Court of Appeals. You can ask for a bond change. They have the power to do that. But I can tell you, I am going to put on an order today that effective November 27th, you are to be arrested and put in the local jail because you have advised the court that you will no longer be paying for the electronic monitoring.
You have no jurisdiction to do so.
That's fine. So you can deal with my order and take it to the Court of Appeals as you can with all the matters that are pending in this particular case. As far as your notice with respect to going to the federal court, what type of case is that?
On December 14th?
You gave me a new notice that you're due in the federal district court December 14th for a settlement conference. What kind of case is that?
That would be my civil rights lawsuit against Hocking County and AEP and Mr. Trent Woodard, who violated my constitutional rights.
Okay. What time is that conference?
I don't have a clue.
Well, I'm not going to grant you any travel rights until I know the time that you're
Well,
there.
sir, if you want to tell the federal court that, then you tell the federal court that. But I will be going, okay? And I won't be in jail, and I will be going.
Well, I can assure you that if you're in jail, you are not going to be released from the jail to go to the federal court.
I'm sure everybody would be happy. Everybody in Hocking County would be happy if I didn't show up for a settlement conference in federal court against the county.
Anything else?